Well, the topic for today is infringement and passing off of IPR. Now, before I say anything about infringement and passing off, let me say something about IPR in just a brief. What exactly is IPR? Why IPR is important for the economy, and how IPR works for business. Because once we know the relevance of IPR, then only the infringement and passing off becomes more relevant to understand why and what to do in that particular scenario. Well, I'm just talking in a very simple language. I may use Hindi a little bit here and there so that we can just have a very open session about IPR. IPR ज्यादातर in local market when you say IPR, बहुत सारे लोगों को एक ही चीज पता होता है, उसका मतलब होता है brand name. Right? Nobody knows, nobody says like design or patent. What they say is brand name. So if you say IPR means trademark, local law mein, yeah, it is very much clear कि IPR बोले तो trademark. But as a lawyer or as a lawyer or as a law enthusiast, or if you are a person in law, then definitely IPR is not only trademark. IPR is all about patent also, design also, trademark also, copyright also, and there are many others also, right? So the moment I say IPR, it includes everything which is more of a creativity and which definitely falls under TRIPS and everything. Now, what is the importance of IPR in business? आज के तारीख में in today's world, where definitely we have come to the very global stage in a very short distance, without IPR, there cannot be any business. I'm using this word cannot because majority of the business comes from IPR. Now that becomes a very different thing, how you manage your IPR, how you understand why IPR is relevant to your business. It is a different sector, but as a lawyer, I will prefer you should know that how IPR manage business. Because unless and until, if you're an IPR lawyer or IPR consultant, or you want to know more about IPR, or you may be in the field of business development, or might be in the field of consultant in any post in any company, you should always know the importance of IPR in business, और किस तरीके से business जो होता है in business has to merge with IPR so that IPR and business they grow hand in hand. Any business what we do today is all about IPR. Now it starts from the day one when you think about any concept or idea. It is true that idea cannot be copyrighted, but there are many ways how you can do it. There are many ways how you can protect your idea also, a concept also, a note also. So the day when you start understanding the business, this is the business I want to do, this is where your creativity starts. The day your creativity starts, your IPR starts playing with you. And if you are master in playing with IPR, you are a good businessman. And if you're a good businessman, you need to meet a good lawyer to understand how IPR can be played in your profit wise, right? So definitely, there are many companies nowadays where they only work on IPR. I don't want to name it, but there are many. I'm going to say today, so there are many. There are just innumerable where they only rely on IPR and they're doing the business. Now, why business as a person, you should know what is IPR. Now, the reason I am saying this because it has many sectors. Most of them, agar aapko pata hai how pharma companies in India, they are in certain categories, then you should know ki how the business people are playing with IPR laws also and are doing with IPR business also. How it depends on what is your criteria. So now I've just covered what is IPR, what is the importance of IPR in your business, and what businessman has to do with the IPR, right? As a businessman, protect your IPR from the very day one. Don't use the word assumption and presumption in your business. If you are a lawyer, don't even use the word assumption and presumption for your clients. If you are a student, just note that you never knew what is assumption and presumption in law, because IPR never works on presumption and assumption. It has to be on the spot. That's it. So there has to be no plus minus. The day you decided what you want to do, jump into the IPR forum and go for it. Now, what is the area of protection you claim for? It depends on your expertise. It depends on what you want. It depends on what you claim for, right? I'm not getting into, but just give an example that how a business starts with an IPR. The moment you think about IPR business, you start with the name of the business. You register a company or you start a firm, that becomes a trademark. There is a business model, you believe that it can be copyrighted, you can think upon. Having a business concept to be copyrighted is a very different portfolio, but definitely you can think of. If you think you have very innovative something you have done, go for a patent. If you think you have something very products which are very much designable, go for design. You start your business, carry on your business. In your business, IPR has to be on the first part or maybe second part, because finance becomes the first part, first part. So this is where I just want to close this particular aspect. Now, what happens and when infringement comes or passing of kab aata hai, right? I'm just giving you one example. Machine cutter hota hai. There's a marble cutter, which is very famous. Everyone knows that, but there's one brand which is very famous. It is from A. I'm just labeling it as an Anup. Now he started his business by the brand Anup cutting machine. Okay, it is very much local in Mumbai, but it has gained a very much huge demand over the period of time. Now this guy started a business. There is he never applied for the IPR as a word per se, but he only applied as a logo or as a label. He got that particular mark. Now he's using the mark. Okay. Now he's not even bothered to find out कि market में कौन क्या use कर रहा है, and he's not even bothered to know that who is trying to copy him. He's not even bothered to know कि what are the marks which are there in the market. So here, because of his non-interest, one person jumps into the market and use the word, like his name is assume Anup, just an example. He started Anupama, and he got the mark registered and is doing the mark. In these 4 years, this Anupama gained more prominence than Anup. Now Anup wants to fight a case against Anupama, saying that this Anup is my name. So the question mark comes, whether he will get or not is a different thing. Question mark comes, whether it is an infringement or a copyright, passing off. Now, what is an infringement and what is a passing off? It is a matter of law, but in very common. Let's be understand. In trademark, it is not mandatory. I'm using the word that you should get your mark registered with government or with IPR, IP India. It is not mandatory. Same with copyright. But yes, for patent and design, you go for it. It is indirectly becomes mandatory. But for trademark and copyright, there is no mandate. You have to get it registered. And this is where the whole purpose comes, that why there's an infringement and why there's a passing off, right? Now the time, this particular Anupama, he applied for the registration. So Anupama applied under class 35. Okay. And he claims to be a manufacturer. So I'm just giving you this one example, and I'm just trying to cover the IPR infringement and passing off. So Anupama filed under class 35. Just to say what is class 35, there are total 45 classes in IP for your mark to get registered. Now, for the purpose of knowing how it works out, from class 1 to 34, it is a manufacturing class. Okay, from 35 to 45 is a service class. But then I always go with this funda. 1 to 34 is the manufacturing class. Forget 35. 36 to 45 is a service class. Class 35 is the biggest loophole, or you can say the biggest player in the market. It is a class which I refer as a retail class. I mean to say, agar aapko kidhar kuch nahi milega, go for 35. 35 is being played very well by those marketers or those companies who wants to use similar mark of other company. Now, Anupama, he filed under class 35. Okay, and he claimed to be a manufacturer. That Anup, he filed for his mark as a machine cutter under 11th class of manufacturing, and he failed to file under class 35. Pause. This is where knowing IPR laws and to know how IPR works for business and how you should choose a consultant becomes more important, right? So he failed to file under class 35. So now the question came, he went to his lawyer and he said that I want to file a case. Infringement can usko ye sab pata nahi hota hai. They don't know what is infringement and passing off. What they know is I want to file a case. So now the question came before that particular consultant, which case to file? Infringement or passing off? Well, he can file an infringement. Infringement is a statutory right. It is given under the law. What is infringement? If you are a registered owner and if someone uses it, it amounts to infringement. But if you are not a registered owner, then you cannot claim as an infringement. Then there is a common law remedy which is called as a passing off. So infringement and passing off both are different. Intent is same. Definitely the features are different. How it works is a different part. But the main goal and the main relief is same. What? I want that particular defendant or opposite party to stop using the product which is affecting my market and my customer. This is end of the day, सबका यही goal होता है कि I don't want him to use my product using my name or nearby or thereby having the same customer in the same market. Well, he issues a notice. Anup issues a notice to the Anupama saying that you have infringed the goods. Anupama replies to Anup that I have never infringed the goods. Even I have applied for the mark under class 35. So I am a honest user. I'm not using the word honest concurrent user. Okay. I'm using the word honest user. And this is where the whole matter gets stuck. So, I want to pose a question to anyone who can reply me right now, whether this amounts to infringement or passing off. Okay.
Any
For me,
participant?
anyone wants to reply, you can reply. So just I can move on. Is it an infringement or passing off? Now the case is, for me, it is an infringement. It is a passing off also. How? So I'll just figure it out. Now, infringement is if you are a registered owner, it is a statutory right of yours to stop someone from using the same mark. Now the question comes whether Anup and Anupama is the same mark. If you ask me, no, Anup is a different name, Anupama is a different name. There is a very settled principle of law that you cannot break the words and then you can decide what is generic and what is non-generic. You need to, okay, passing off. Okay. Now you need to understand that whenever the mark has to be understood, it has to be understood as a whole. You cannot break the mark. Like you cannot say Anup and Pama, Anupam. Nah, it is one word, Anupama. And there is one Anup and there is an Anupam. Right? Now he issues a notice of infringement and they reply saying that there is no infringement. And neither there is a case of anything, and we have just we have gone as per the law, and now we are the owner of the mark and we are using the mark. Now this is where the Anup got stuck, and now what to do? Well, now the passing off comes into the picture. Okay. Now I am pausing myself, and now this is a very relevant question to you. If there are two registered owners for a mark, okay, for a mark, and they feel the mark is similar, and if the law feels the mark is similar, but if there are two registered owners for the same mark, for the same consumer, for the same market, having the same supply of channel to distribute their goods, what is the position of law? Now, I want if anyone can answer when I complete my lecture, but I'll reply to this meanwhile, when I'm just covering this topic. So now Anup, Anup issued again a reply rejoinder saying that no, you have purposely used my name to gain my goodwill, and now you are claiming to be the owner of the mark, which is not proper and infringement and passing off. Now Anupama replies to them saying that I have applied for the trademark. This is my trademark certificate. So there is no case of infringement. And since you are blaming me as a passing off, you don't fall under the passing off because I have never touched your product. It is my own product. And in regard to the marketing channels, they replied saying that any businessman will have the same marketing channel and there is no dispute. I cannot create new marketing channel and hence you don't have any right. So now the case comes, what is infringement and passing? That's it. Now infringement means statutory right. You have to prove that he has used the mark. Anup has to prove that he has used the mark. Anup has to prove he is a registered owner, use the mark, that he's creating an identical mark in the market so that even my business gets down, infringement. He files a suit in the court. Then he goes to the court and says, and he has filed a combined suit, okay? He has went to the court saying that Anupama has infringed my mark and there's a passing off also. So now the question comes before the court whether it is an infringement or passing off, right? I am pausing myself. Now, what is exactly the passing off? Passing off doesn't only come, if you use identical mark or not. It has other features also. Just for an example, if there was a brand by the name Minimalist. If you check to Google, if you go to Google, now normally, cosmetics, skin cosmetics, they have this particular habit of packaging, the bottle, and they will define everything, how your skin works and everything. But this particular brand, Minimalist, he copied the simplicity of another brand, which they just had a label in it. It was a simple plain label. He just used the name. That's it. Now, what Minimalist, there's a brand by Minimalist. He copied the same thing in the market and he launched in India, right? So how passing off comes into picture? If there is a direct touching to your mark, identical mark. If there's an indirect touching, if there is a reversal also, if the trade dress is same, packaging is same, look wise gives the same feeling, purpose is same, intent same. How intent comes into picture? By the term used called prior user. If these 4-5 features are there, even if you are not registered your mark, you can go for a passing off. Okay. Passing off means that if you are able to say in the before the court, or able to prove same product, his mark is exactly or nearby to my mark. He is trying to be an identical in my market using my own way of packaging, same color combination and everything. The moment you are able to do this, it is a passing off. Definitely, if you come with an infringement. So this matter came before the court, and the court said, you tell me first of all whether Anupama is a good mark or not. So Anup was not able to prove it. He said, no, according to me, Anupama is a copied word. And they had the argument saying that, no, the first 4 letters are, is a copied word from mine. And definitely the Anupama's counsel stated very clearly that Anupama itself is a name. You cannot bifurcate the name and say Anupama Aya. Now, this is where Anup came into picture by the claim of saying that, no, it is passing off, and they have purposely used this name. Like Anup was already my name, they have just used the word Anupama. And because of this, they have entered into my market, they are approaching my customers, they are using the same channel. So definitely, the court went into this, the court saw trade dress is same, the packaging is same, the color mechanism was same, the white background was same, the font, definitely it was nearby same. And the court came to the conclusion, ki fair enough, this is a case of a passing off because your intent shows. Now the question came before the court saying that who is the first owner? Who is the prior user? This is where I am able to say, if you are, even if you are not registered, but if you are able to prove that you are the prior user and it has a goodwill in the reputation in the market, and the copied product or whatever the product is a misrepresentation in the market, if you are able to prove it, you can go for a passing off. This is the very thin line between an infringement and passing off. Okay. If you have any questions about what is passing off and infringement, you let me know. By the end of the lecture, I'll explain to you. So that particular passing off order was passed and everything was done. But now the question comes, for Anup was what to claim, how to claim, what are the remedies and everything. Now, in this particular court scenario, Anup, he wanted to, file for an injunction. So he went to the court and said that I want them to get an injunction because I don't want my product to be used. So he went to the court saying that I want to enter, Anton pillar order. I'm pretty much sure everyone knows what exactly it means, right? It is like, you are asking the court that we want to investigate the premises. We want to see whether they are using the product or not. And I don't want them to destroy the product because the moment, so there is always a risk of a defendant destroying the product because even they are aware that they might go to the court. So on this particular, whenever there is a chance, you can go to the court and ask for the Anton pillar order, which is very famous phrase, and go for it. And then definitely the second part comes where you go for the Mareva injunction, where you want to freeze the assets of the defendant. Okay, basically most of the parties to go for these orders. Specifically, when you feel that the goods are movable, are very perishable sort of, then definitely there is a third option when you go to the court saying that I want an injunction for a time being. We can say we say no interim injunction and as such. And then there's a perpetual injunction. Definitely it means that you can go for a final injunction and everything. So these are definitely the remedies are all about. In passing off and you can go for it. Now he went to the court, he applied for everything. He got the order or not, it totally depends because for you to get an interim injunction also you need to prove your case beyond doubt. Okay. So let me say there is a case of a Kimia dates. Everyone might be eating Kimia khajur, dates. So what has happened is that this particular company, they launched a product by the name Kimia dates. Okay, Kimia dates. And he was doing very well in the market. And another player, he started with the name Limia dates, Limia. Okay. And he used the tagline Kimia. So this particular company, he went to the before High Court saying that he has used same identical name and he went to the court for injunction and everything. Well, there is no surprise that the High Court, respected High Court, he declined interim injunction and any order. The reason is date, in Iran and Iraq, kimia means dates. Kimia means dates. So there was no copy. So there was no copy by them. In fact, they use the word which is very related to your product which you are selling, and it is itself is a name known to be called as a dates. And he lost the matter. Right? So basically now if you go to the market, you will find everywhere Kimia dates only. So now most of them have changed from Kimia to Limia, Simia, Timia and everything, because there is a very nearby mark to Kimia, and Kimia itself is a date, right? So you should know when to file an infringement, when to file a passing off. Now the question comes, what are the legal remedies? Well, there are many legal remedies. As I told you, you can go for an injunction also, you can go for inspection also, then definitely there is a final permanent injection, what you say. You can claim damages, you can claim profits, you can claim calling their accounts and everything. And the way I see today, IPR suits whenever they are filed, injunction is a top priority. And if you are able to prove your case, I think within maybe on the date of filing also, or as per the procedure, you will get an injunction. If your suit is very well drafted in that particular way. Now passing off तो ये हो गया है, injunction ये हो गया है. Now how exactly we can come to the conclusion that and what is the reason that we should not file trademark? So I'll tell you one more case. Most of them, I'm just touching on pharma industry. If anyone practice in pharma, so let me tell you that in Bombay, I don't want to name the place, in Bombay, you will find same name copied in a different way. And there is a very settled business which is going on. So how it works, I'll tell you. Suppose if you have got a good pharma name saying that, I'm just taking a name, of aspirin. Okay, I'm taking an example of aspirin. Okay, it is just an imaginary name, nothing to do with the real product. Okay, so there are players in the market who use aspirin and fasprin, sasprin, and anything related to this. And what they do is they don't even register. They will just use the mark. Okay, the moment they get the notice, they will withdraw the mark, saying that we are sorry. So whether you want to go ahead with this particular passing off or injunction, it depends on you. Now the question comes, most of them, they are very smart. What they do, they only copy the mark nearby, but their product packaging is different, because they know if the product packaging is different, okay, no one can get into their trade dress and everything, and one can claim for passing off. What at best can be done is infringement. And the moment they come for the infringement, they say, I never knew this mark exists in the market, and according to my interpretation, this mark was different. So they will withdraw and they'll give an undertaking. And this matter is very much common in pharma, in cosmetic industries nearby. Okay. So, but as a business owner or as a legal consultant, we should know when a passing off comes into picture, when infringement comes into picture. Because both, definitely the outcome is same, but the purpose, but the way out, but the way you claim is totally different. If in case your mark is not registered and you file for an infringement, no relief. If you file for an passing off, but if you are not able to prove the common similarity in your packaging or in your product or identicalness or nearby, you will fail. So as a businessman or IPR or a legal person in law, we have to understand what exactly this particular case comes to, infringement or passing off. Okay, remedies are there in law, even if it's a trademark or a design, or go for copyright, you will get the relief which is there in law. And now relief is very clear. First, stop them, damages, call their accounts, your loss, marketing cost, and everything. Now, this is just, I'm just sharing one point, that whenever you file a suit before the court claiming your, reliefs and prayer, it becomes more important for you to claim what was your turnover, what was the expenses you have made in creating a product or a brand or whatever, what is the monetization you have given for ads, what is the sales, definitely as a turnover it comes sales, what are the profits nearby you have gained, before knowing this and after knowing this. Because at the end of the day, if you are able to give this particular scenario before any respected court, you actually have done your duty more than half, right? Because name is similar or not is an interpretation part most of the times. Basically, in prima facie, you can understand. But if you are able to prove your stand in the market, then that removes most of your argument. Now, the only question comes is about the mark, whether it is similar or not. Then definitely it is a part of the interpretation where the mark goes or not. So now I'm just sharing one illustration which is more important, and I want if anyone can reply to this, maybe at the end of the lecture. So what has happened in one of the cases like this? A person has went to the trademark office and he has filed for the mark. I'm just giving an imaginary mark saying that you can say Exin, okay, Exin, AXIN. He goes to the trademark office and he files and he gets the ownership of that mark, Exin. Okay, in you can say in cuff market, in farm. And there is another company, he goes to the court, he goes to the particular trademark office. So the first person who filed the vaccine, he basically exports the medicine to some other countries. Okay. He was never in India. Now this second company, he goes to the trademark office and he says, I want to sell in India. And he gets the same name advertised, but not registered. Okay, so he has not registered the mark. He has not registered the mark. He applied. So the first company, the owner of the real owner of the vaccine, he files an opposition against the second person who has also filed for the vaccine in the same market. So there is an opposition going on in the TM office. The first player is saying that I am the owner of this mark. How even it got advertised? The second one is saying that you never wanted in Indian market. You wanted to sell in outside India, and also we have gained the popularity in India, and we are selling the product in India. So when this particular cases was filed, second party was not okay. So now third person comes into picture. Third person. He files for, like it was AXIN, he files for FAXIN, vaccine. That's it. Now he files for that. Okay. He files and he is selling also outside India. Okay. Now the second party, he files a case against the third party saying that I am the owner of the mark. But he has not disclosed that even he has copied the mark from the first party. Okay. Now there's a huge question, I want to know whether there is a case of passing off or an infringement. Now I'm just pausing myself and I want if anyone can reply to this so that I can go to the next step. What exactly?
I mean, so far the discussion is going on. Is there any, I mean, vital points in 4, 5 bullet points you can say that what will be the difference between passing off and infringement? I mean,
So that can be addressed later on. Actually, now Lalit sir asked the question, so if you could
okay,
answer that.
okay.
Okay, I'll reply to you just after this particular point. No problem.
Any participant who would like to reply to sir, whether it amounts to infringement.
Okay. So since there's a query raised that you wanted to know what is the passing of an infringement, I will just give 4, 5 points so that you can understand what it is, and then I'll come to that particular query. So the difference between a passing off and an infringement, if you see from the legal point, is passing off, it comes under common law, right? Because it is an unregistered mark, so it falls under common law, which is very well defined under Trademark Act. Infringement, it comes under statutory law. Okay. Now passing off is always for the unregistered part, not a registration part, because registration is taken care by the infringement. Okay. Now the passing off is always based on, as I said, what is your usage, what is your goodwill, what is your reputation in the market, and if you are able to prove that I am the person who has acquired a goodwill in the market. So there is a lot of proving you have to do for the passing off. But for the infringement, since you are already registered, you have got the right for the exclusive right. So you are the sole owner of it. Okay. Now in passing off, since you are not a registered mark, you need to prove that the mark which is there in the market is done with an intent to misrepresent. Most of the time there's a confusion part. So you need to say if there is any misrepresentation or a confusion, passing off comes into picture. But for the infringement, you need to prove it is identical or similar registered mark, even though if it is not registered for opposite party. Okay. In passing off, most of them, when you don't go for the registration, definitely you have to prove your prior usage. As I said, turnover, you need to establish your goodwill in the market. But since if you are registered, you don't have to prove anything. You just have to say that I have been using this mark continuously. Okay. And the biggest, where the evidence comes into picture is in passing off, you have to prove there is an actual confusion. There is an actual confusion. But for the infringement, you have to prove likelihood. So there is a lot of difference when it comes to passing off and infringement. In infringement, you proving is not much higher than in passing off. So that was the answer what you asked. And now I'm just coming to that particular, illustration, Axin and Faxin, right? So that particular second person, when he filed a case for the passing off. He never filed for the infringement because his mark was never a registered mark. Okay, so he filed for the passing off. Third party, he files a reply. He files a reply to that particular case saying that there cannot be even a passing off because even he is not the owner of the mark. The owner of the mark is the first party. Okay, so now the situation has come whether the second party can claim passing off when he himself is not the owner of the mark. So this is a very different situation, right? Now the first person, where he has already filed an opposition against the second party, okay, he has claimed that they cannot be the owner of the mark. So the second party was, can he get injunction order in his favor since he's not the owner, but he has used the mark. Now this particular case, it takes care of infringement also and passing off also. Okay, now definitely, the third party went to the court and said that this is not even a case of a passing off because the mark what is trying to prove there is no purpose of confusion because I am selling in outside India. Now he has registered in inside India and his application says he wants to sell in India and he has copied the mark of the first. The first person has already filed a case saying that I am the real owner of the mark and I have, as per the trademark, even if you sell the product outside India, since you have registered in India, you become the Indian user. So now there are three parties. The cases are filed for infringement and passing off. So now who has passed off the goods or infringed is a matter of interpretation, which is before the court of law. But yes, as a third party, FAXIN, they have already stated that my mark is a separate mark. It has nothing to do with Exin. But definitely in this particular case, there are all three things have combined. Infringement, passing off, infringement and passing off. Now I'm just pausing myself. Now I want to know, is there any query you have regarding passing off and infringement?
Any queries, participants? And we would prefer if you all can ask directly. If not possible, then you can raise the query in the chat box. Sir, in the chat, a participant is asking whether using the same color can amount to infringement.
Well, if you're talking about infringement, same color, if it, the consumer base is same, and if your mark is different, then no, But if your trade dress, your packaging, if your mark is nearby same, if not identical, nearby same, and if the impression of that particular product gives an impression of the well-known mark or already named in the market, then it might fall under the impression infringement. But yes, if your mark is different, okay, and your color combination is, even though assuming it is same, but the impression is giving different, or it has a different consumer base, OTC counter, whatever, then you can be free from this infringement part. It depends on what you use and how your trade dressing is. Only color you cannot define. Just for an example, suppose there is a color red, you are using it, and in bottom you are using some bullet points which they have not used, then you can claim as a right of a separate trade dress, nothing to do with that.
Yes, good evening. Is the same thinking applicable for copyright?
Okay, so your question is like in copyright there's a passing off or not?
Is the same thinking, yes, passing off infringement kind of thinking applicable for copyrights of the books, etc.?
Go for it. Yes, you can claim combined. Because in copyright also, it is not mandatory for registration. But the moment I say copyright is not mandatory, there are certain sectors which is more preferable for getting registration. And then infringement comes into picture. But suppose if you go for a copyright which is unregistered, then definitely passing off is a part of a copyright also.
And if there is no contract signed between the publisher and the copyright holder, and still the book is published and the contract is not signed because of some dispute of royalty and all that, and he went ahead publishing it, can we stop him?
Yes, you can stop him because at the end of the day, you are the moral author of the book. Number one. Second, since there is no contract, he doesn't have a right to publish unless and until you have given, there is already a talk which is not a part of the contract. So assuming that there is no contract signed, then definitely he will not publish it, because at the end of the day, he has to prove that he is the owner of the publishing mark. So he will not do that. If you do that, you have a right to go for the injunction, because end of the day, even if they are a publisher, the moral author is the person who writes the book.
Right. But in the transition period, when you are negotiating with the publisher and the terms are not agreed yet, but for the convenience of the reader, the book is already published by him.
Please.
So in the transition period, because there is no agreement, no agreement on the terms, the contract is not signed, and he has gone ahead, publisher has gone ahead for the printing for, let's say, 10 years or so. What happens?
It's like this. It depends what is the negotiation going on. So I'm taking two scenarios in this. One, there's a negotiation going on saying that the person who has wrote the book has said that you carry on with the printing of the book. However, I'm not okay with certain terms which we need to discuss. Okay. So it totally depends what negotiation you are having. But whatever is the assumption and presumption, whatever, a publisher cannot publish the book unless and until the author has signed the contract, because they don't become the owner of the mark, particular book also. So suppose even if the publisher goes and print and there is no contract, the burden is on the publisher to prove, saying that no, he gave me the consent to publish it. So now you don't have to prove. There is no burden on you to prove. They have to prove, saying that how you got the permission to print the book. Because without contract, no one will publish. But if they have published, then it is beyond law. I mean to say, then definitely they fall under the infringement part.
Understand.
So you can get an order of this.
And for doing this, the first thing you have to do is go to the police or write to him. Just write to him.
See, it's like this. There are 2-3 things if you see that way. If the book is published and if you are not aware, but if you got to know from the market that the book is being sold, right? Then definitely you have to go to the court to get the protection worldwide, number one. Because going to the police will not help you in any case. Second, if you go to the police, you need to prove that you are the owner of that particular book, that you have written the book. So going to the police is not a bad option, but I will prefer you go to the court. And in regard to third part, definitely that becomes the very first part, that you issue a notice to them on the spot when you got to know, saying that you have to stop because there is no approval from my end to go for the publish of the book. And give 24 hours and 48 hours, so that in this 48 hours you can prepare your suit and go to the court. Because if you go to the police may say that you need to prove your ownership so that I can go ahead with the further process of filing an FIR against them.
Okay, I understand. Thank you.
Sir, what is the... Sorry, please ask us.
So there was a question, I just saw the chat book. How can the opposing party prove that their use of someone else's trademark was unintentional? Was the opposing party proof that their use? Is there any way they can get acquitted? Okay, see, how trademark works or copyright IPR works is like this. Now, intentional and unintentional, we get to know if the period of experience you have in the market actually. Now, suppose if you are a player in the market for 10 years, then there is an assumption that you know how the market works. And in today's date, if you are in Bombay, you go to Google and find out कि ये नाम है या नहीं है. You will get to know कि Bangalore में मेरा नाम use हो रहा है नहीं हो रहा है. Assuming also you are an unintentional player, then you can go for the claim that I am the honest concurrent user. I was never aware that this mark is already there. And then definitely, you need to prove your intention. Regarding the mens rea, see, mens rea is for the intent part which comes under the CRPC. In trademark, you just need to prove that I did my best. I'm just giving an example. You started your business, suppose somewhere in, I'm just talking about Bombay, suppose you have started a business in, a very local place, you can say Titwala. Okay. Now, you are a very small player. You started the business by the name Reliance Enterprises, and you are not aware what is going on. Okay. You have started the business. Now you have got the notice saying that no, Reliance is the brand owned by, one company. They go to the court. Now you can say कि मुझे मालूम नहीं था, ऐसा नहीं है. But see, the problem where it will come is about the experience of you doing the business. And Reliance is a very well-known name. Suppose if you go some another name, and then if you are able to prove it. But let me tell you something that where you have used the mark unintentionally, and if you go to the court and say that I never knew this mark was used, I am ready to withdraw the mark and I will undertake not to use the mark, and the matter is over. Even the courts understand, because we in India, like most of the markets are unorganized, more than 65%. So even they understand who has done intentionally or not intentionally. Recently, if you have seen the that particular case of using the word 6E by Indigo and Mahindra, so that is not the case of unintentional. It was purely intentional. Okay, but if you see some another usage of the mark, now assuming that if Mahindra would have not used the mark CE 6E, suppose if a very small person who is doing a local business, he would have started using the word 6E. I'm pretty much sure it falls under the case of unintentional, but it totally depends on the particular facts of the case. And there is nothing called mens rea when it comes to trademark law. Everything can be proven on the face of it, and by the act of the parties, one gets to know whether it was unintentional or intentional. And at the end of the day, in IPR suit, damages is a separate thing. What they want is stop using the mark or stop using my ownership. That's it. Most of the time.
Okay, sir. So there's one question. What is the period of limitation for a trademark infringement suit?
Okay, the limitation for the trademark is 2 years, and it is from the date when you got to know. Now, if you want, nobody will wait for 2 years to go to the court and file the case. So the day you get to know, issue a notice and file within a month, so that you can get an ad interim relief. Now, suppose if you go after 1 year, waiting for 1 year, law doesn't say that if you come after 1 year, we will not give ad interim. But why to wait for 1 year? So better you go as early as possible. And in regard to when you get to know, so that limitation starts, when I started my lecture, I told you very much clear that it is very much important to know that why IPR is the part of the business growth, and why all the business persons should know the IPR. And this is where we as an IPL consultant or a lawyer practicing in IPR should know what advice we have to give to the business. There is a very much good practice saying that you should always go for the good search every 2-3 months, so that you know what exactly going in the market. Now suppose if they have not filed in trademark and they are just using it, and you got to know from the Google, then from that day 2 years. That's it.
So one question from the registration form that I'm taking. What evidence can be produced in infringement cases?
See, in infringement, you need to prove your registration certificate, you are a registered owner. As I said, you need to prove that you are using the mark, give your turnover, sales, take a CA certificate saying that I am being expenses itna ho raha hai, this is my expenses, this is what I am earning and everything. If you are able to do that, and then you prove that the second party is using the same name, that's it. This is more than enough. Because once you are a registered owner, you don't have to go beyond doubt to prove. But in passing off, you have to prove yourself, saying that opposite party का ऐसा ऐसा है. So when it comes to proving, infringement becomes more easy. Passing off takes a little time because you need to prove your case.
Is it mandatory to serve a notice before
Well,
filing a suit?
Well, it depends. Most of the time it becomes mandatory, so that they inform. But there is nothing as such a law which says that you need to issue a notice to them, because nobody will wait. Suppose if you get to know there's a perishable product, right? You will not issue a notice saying that no, you do it, then I will not go to the court. The person will directly go to the court and say that I never had the time to issue a notice. Please give an injunction. So issuing a notice is not as such a mandatory. But yes, even the court prefer that you issue a notice. But when to issue, not to issue, what is your position of not issuing is a different case. Now, suppose if the movie is being released tomorrow and you got to know 2 days back, they have not used your name as a credit in one of the way and they have used some another's name, then you cannot issue a notice and wait for 2 years. You will directly go to the court and say, I was not able to issue a notice because the time was not there, and law will go with you.
Okay, sir. So one more question. What is the formula for calculating damages?
Okay, see, there is not a such formula, but there is a simple formula. There is an accounting policies. There are ways how you can quantify your claim. So let me say something. This is what I normally advise. Now, what I have seen is nobody, they put their brand valuation in their balance sheet. Now, this is, I have not seen most of the times. So the first step is, even though your brand value is 1 rupee or 10 rupees or 100 rupees, put your valuation of your brand in your balance sheet from the day one, because you don't know when this particular will be used. Now, what happens is that when we don't put the valuation, then the question comes कि how your value. Now, basically the valuation is like this: आपने कितना आपका growth हुआ है, what is your income growth, which becomes more important, what is your expense growth. So जब आप अपने investment को और expenses को profit के साथ match करते हो, in accounting language it says capital employed ratio. You can use that ratio, but there are 2-3 ratios which are stated very clearly. So there is as such no mandatory कि आपको यही formula use करना है. You can use your own formula also just to come to a valuation part, and it is very easy. आप अपने बैलेंस शीट में दिखाते रहिए आपका कितना ग्रोथ हो रहा है, कितना टर्नओवर हो रहा है, कितना एक्सपेंसेस किया है, and if you divide and adjust with them, now you will get a ratio where you can say, okay, this was my ratio, now I need plus 20%, because of him it has fit my market. Because कोई भी market develop करने में it takes a time. It is not one day job. It takes 6 months, 8 months, a year also. So put that into mind and claim for it. I'm not saying that आप claim करोगे तो आपको सब मिलेगा. And that even court will see, in India we don't go for this compensation relief as such in a very big way. ठीक है, relief आपको कम ही मिलेगा, but you should be ready with your valuation.
Okay, sir. इतने questions थे.
Okay.
Sir, वो जो एक और question था registration form में, what I told you before the beginning of the session, what are the career prospects in IPR? Would you like to answer that?
Career prospects in IPR. Okay, one, if you have cleared your law and you want to practice, then definitely it is a very good scope to practice as an IPR lawyer. But just with the pause that if you are an IPR lawyer, you should know how business works. Just as a lawyer, and if you are not aware how the business works, according to me, it doesn't give an output, because an IPR always has to be read with business. It is not that you have to fight always. You should know where to fight, not to fight. And it's not about money. It's not about your business. Okay. So there's a scope of you being a very good litigation in IPR lawyer, as an IPR lawyer. If you work in a company as a lawyer, suppose if you're a lawyer in practicing in a corporate, then there are nowadays many corporates, they hire lawyers just to use their expertise in knowing whether this mark is good or not, what to do, what are the strategies to be formed, and if I will prefer, if anyone wants to practice in law, they have some kind of management in brand also, so that they understand how branding works. Then there are very, if you don't want to practice as a lawyer, then definitely you can work in a corporate. You can be an IPR consultant also. Even if you're a CA or a CS, you can be an IPR consultant. At the end of the day, you should have that mind of knowing what mark will be good to be taken forward. Not, you should know how to analyze the mark. It is not that every mark which is nearby is a bad mark. There are marks which is nearby, but you have a potential to say, "Nee, this is the mark where I can, go for it, even though objection comes or not." And there are certain marks also that requires your skill to know. So, I'll prefer that whoever is practicing, start reading the judgments, because most of the judgments, well, there are judgments which are more confusing nowadays, isko mil gaya na isko mil gaya. But what I will prefer is you read judgments and to find out what is the relevant submission they made before the court. Order is an order. I'm not saying that, but don't read the judgment only because of an order. Find out what the submissions were made, because in IPR, most of the submissions is used as a strategy for your business. So see, assuming that a defendant lawyer has used one ratio, there was a case I remember just recently came, Adidas something, where a defendant lawyer has given a submission that Adi is my sister's name and Das is my surname, and he came with a very innovative idea of argument. He failed, I'm not saying that, but his submission was very brilliant. So I think we can take those submissions in our book, write it down, and use somewhere when it comes, because that becomes a more relevant part. And if the matter is failed or not, definitely, it depends upon who is fighting nowadays and everything, but go for it. So there are many scope as a consultant also, lawyer also, practicing lawyer also, go for a corporate. In pharma, there are many, companies, they hire lawyer who has an experience in knowing how IPR works. So there are many things, you can do that as a career advice.
Yes, Jain sir, it's not a question. I have sent you an invitation on the LinkedIn if you could connect. I'll be obliged.
Okay. Okay. Thank you.
Thank you,
Thanks.
sir.
Thank you.
Thank you.
Thank you. Yeah.
And good one. I enjoyed it.
Thank you. There's a question. If the companies are in similar type of business, but one is multinational base, including Bharat, and others having customers within Bharat, what companies? A mark is a mark, you know. A mark is a mark. If you are in Bharat or somewhere else, if MNC company has a customer base in Bharat, and if you are doing the business in Bharat, then that amounts to infringement and passing off also. And it depends, you know, what you do, what you don't do. But if your question is that whether it will amount to infringement or not, yes, it will amount. So it has nothing to do with your local Bharat and everything. A wrong is a wrong, you know. That's it. Under trademark law, if a person registers a trademark but fails to, yes, if you don't use the mark for 3.5, you know, 3.5 साल तक अगर आप use नहीं करते हो mark, even if you are a registered owner, then you lose the right of using the mark, you know. So yes, PK for extended and then when applies for the streets similar. Okay, that's an interesting question. Under trademark law, if a person registers a trademark but fails to use it any for an extended period and another person applies and start using without approval, then the second. See, this is what I was saying. You know, even if you're a registered owner, if you don't use the mark for a particular period of some 3.5 years or 5 years, then in between someone applies. Like suppose if you don't use for 5 years and then he applies in the very 6th year, then you need to prove that you are using the mark. Then the burden of proof is on you. So even that becomes important because end of the day, the purpose of IPR is to boost economy. It is not that you take the mark and sit idle. No, boost economy. Don't stop creativity. Creativities are the part of the growth. So you by taking all the mark and not using is almost like you are being acting as a blockage in the economic progress. So there is an intent behind usage of IPR. That's why there's a term in copyright and patent, voluntary licensing or compulsory licensing. So if you don't do it, they have a right to give the license of your products.
So, sir, just the last point which you just now mentioned about the boosting of the economy, and hence you have to register it. Now, the same case of publishing, after having got this material, the publisher has taken the ISBN number. Will it affect in any way the claim which you said that you can write to him?
See, ISBN number is always taken when the book is about to be published because before that you cannot publish the book. Okay. Now, if he has taken the ISBN, then definitely he must have used your consent as a right to take an ISBN number.
No.
So this is where your case becomes, because I never give the consent for you to take an ISBN.
No consent is taken.
Yes.
Unilaterally, the publisher went ahead and he has not given a single pie as royalty. Of course, whenever royalty, please give me royalty whenever he is asked, he used to send the books, a number of books, not a single rupee transaction.
So if you are within that particular bracket, issue a notice and rather than claiming loyalty, you go for the damages because royalty may they hardly pay you 35. If you're a first time author, they will pay you hardly 30%. If you're a successful author,
10%. That's 10% he was offering, and that's why the deal is not signed.
I know, because even I have wrote a book. So it's all about, that's what I'm trying to say now. I will suggest one procedure. What you can do is, what I do normally when I write a book. The moment your book is complete, you file a copyright first. You become the owner. And then you go for a publishing part. Most of the time, what I see is, when a person, he writes a book, he directly goes to the publisher and says, "Kya mera publish kar do." Don't do that. The moment it is finished, see, no book is perfected. Okay, there is nothing. We are not like earlier people. अगर आपको लगता है आपका book बराबर है, even 80-70%, file a copyright. Even after that, you make some changes, file a copyright. You get diary number and registration आते रहेगा. This is what I'm trying to say now. The day you do this and then you give it to the publisher, they will always accept what you want.
Yes.
This is the
and
way
I think, before even filing the copyright, you just get the ISBN number first.
No, I'll prefer you file copyright. No ISBN number.
Getting the copyright process is little tedious and time consuming. ISBN number you can get easily.
I know, but see, that's what I'm trying to say. If the day you file copyright, you will get a diary number. Okay. That it itself is a very big thing. And then within 30 days, you need to file the hard copy. That's it.
Okay.
So I will prefer you go for copyright. The reason is, see, copyright is a very settled law, tried and tested law. Okay. So if you go to ISBN, now ISBN has a different ways how you will get it, not to get it. So the burden of proof again comes to you. कि आपको ये कहाँ से मिला? आपने लिखा क्या? Because today, suppose if you sent me 8 pages का note, and without informing you, I got the ISBN number saying that कि मैंने लिखा, I will get the ISBN number. I don't require your approval then. Go for copyright. File a copyright.
It can be filed on online, no, nowadays.
Yes. Go for a copyright.gov.in. There is a login ID. File it. You will get a diary number. The day you get a diary number, within 30 days, you supply the original documents. The moment they get the documents, within 6 months, you will get the certificate. In case there is any objection, you just check online. There will be a term used under scrutiny. If everything is okay, they will say processed. That's it. And nowadays, copyright, they come within 6 months.
And manuscript can be sent, right?
Sorry?
Manuscript can be sent.
Yes. Only after diary number, you have to send the manuscript.
Right.
3 copies.
Right.
In
3
original.
copies. Okay.
Yes.
Okay.
And, yeah. Thank you.
Thank you, sir.
So thank you so much. It was so last. So I don't have any questions, but I will be really appreciating your like if you have been like involved any landmark cases or notable experiences that you have, like you could share with us. So like we would love to hear from your insights, and we really enjoy this thing, and we want to learn and from your expertise in this thing.
Okay, there was one case, I'm just changing the name. So I'm just talking about one movie which came off late. I'm not using because this all are trademark. So what has happened is that the owner, because there were 3 owners who claimed. So one person was there who wrote a book. He wrote a book. So when he wrote a book, there were 2 friends. Okay. Now, when he wrote the book, he failed to get it copyrighted, and he told his partner saying that, okay, let's find out a producer so that we can see if we are able to sell our book. And when they gave this particular books to 3-4 readers, they found it good. But what they did, they gave it to them saying that you modify the particular concept. Your story is good, but you modified. So by the time he was modifying, this particular story was modified by some another person, who became the producer of that particular movie. So the moment he did that, he never knew what is going on, and he was under an impression that I will modify and everything. So he modified, and again he told his partner that, see, I have modified, now you see what to do. So by the time the original script it started as an OTT part. Okay, and he was very shocked to know. So by the time he was shocked to know कि second क्या आ रहा है, the second also came into OTT. And then he started claiming that I am the moral author. Definitely there were many exchanges of letters and everything, and it went to the court, and the court understood that maybe he was wrong saying that, because he was not able to prove it, that how his book reached to that particular thing. Because basically when it comes to such thing, there is always a trust, and I don't believe in trust when it comes to law. Everything has to be written. So what caught the eye of the particular court in that particular thing is that, how come there can be 2 stories with a 2 different climax and everything by 2 another person? It has to be one. And this is where, he got in his favor, and now everything is settled, and maybe you can see more series coming in upcoming.
Thank you so much, sir. But we'll really appreciate if we could have that case name under the chat at least. I respect the privacy, but we would like to learn from that
I
thing.
will do
Yeah, you
that.
can on LinkedIn connect with sir.
Okay,
Yeah, I will
sure.
do that. Because
okay.
see, being an IPR lawyer, the first thing you need to do is that you need to be very confidential, because
Agreed.
this is what even they expect, because the day
Yeah.
you start informing about them, is IPR is like a detective. He's a hidden
Yes.
detective. That's why.
Yes. Thank you, sir. Thank you. Really appreciate it.
Thank you. Thanks.
So sir, end करे?
Yes.
Okay, sir. So thank you so much, like always, for your valuable insights and sharing your valuable insights. And sir, really can't thank you enough for your immense support to our platform. So really, thank you, sir.
Thank you.
Bye, sir. Hope to
Thank
have
you.
you soon.
Sure. Thank you. Bye.
Bye.
Yeah.